Hello, you're watching Addleshaw Goddard's Employment Channel. Unfair dismissal claims represent nearly half of all tribunal claims, and indeed our solicitors tend to find that many of the claims they handle include claims for unfair dismissal. With this in mind, today's programme is dedicated to helping you, as HR professionals and managers, to minimise the risk of unfair dismissal claims in the workplace. We're going to focus on our recent experiences to draw out some practical tips for employers, which should help if you're in the process of or are considering dismissing an employee for conduct reasons. As a starting point, the ACAS Code of Practice on Disciplinary and Grievance Procedures and the ACAS Guide are two very important documents to have to hand if you're involved in a dismissal process. You can access the code and guide by clicking on the links below the screen. They give authoritative advice on how to conduct disciplinary and dismissal processes and are referred to by employment tribunals when assessing the fairness of a dismissal, so their importance shouldn't be underestimated. Any breach of the code could lead to a finding of unfair dismissal, and if the dismissal is unfair, the tribunals can apply a 25% uplift to an award for compensation for an unreasonable failure to comply with the code. So we're going to look at 10 key areas of the dismissal process today, and we'll comment on practical learning points at each of these stages. These are suspension, how to deal with suspending an employee appropriately. Allegations, we'll look at the best way to present the allegations to the employee. HR involvement, what's appropriate and reasonable. Investigation, the standard of the investigation required in conduct dismissals. Witnesses, how to deal with witnesses during the disciplinary outcome. Outcome, tips on determining the appropriate sanction. Warnings, when to take these into account. Appeals, how these should be dealt with. The interplay between disciplinaries and grievances, and the interplay between disciplinaries and criminal prosecution. Sally Hulston, a managing associate and litigation expert in our employment team, advises on these sorts of issues on a daily basis and will talk us through each of these areas in more detail.
In terms of how to best deal with suspending an employee, the ACAS Code of Practice provides that in cases where a period of suspension with pay is considered necessary, this period should be as brief as possible, should be kept under review, and it should be made clear that this suspension is not considered a disciplinary sanction. However, there may be circumstances that you can avoid paying an employee if they're unable to perform their duties, provided that the suspension label is not applied, as more often than not, a contract provides that a period of suspension will be paid. As an example, in the recent case of Burns and Santander, the Employment Appeal Tribunal agreed that the employer was under no obligation to pay the employee when he couldn't attend work because he was remanded in custody. Our news programme on the 2nd of June 2011 comments on this case in more detail. In terms of the allegations against the employee, it's crucial that these are accurate and are set out clearly in the letter inviting the employee to the disciplinary hearing. The employee has the right to know and understand the case against him or her, and he shouldn't try to shoehorn an allegation into a particular rule or misconduct heading. We recommend including a concise description of the facts as well as the allegation in the invitation letter to ensure that the case is clear and there's no ambiguity. In terms of HR involvement during the disciplinary process, thought should be given as to whether it's appropriate and reasonable to use the same HR support for all stages of the process. The role of HR can be to provide advice and support, and they can ask questions to provide clarification. However, the more involved the HR person is, the more risky it will be if they're involved at all of the various stages, as the employee is more likely to be able to claim there's been bias in the decision-making process. But if the HR individual is simply a note-taker and not the decision-maker, then this should be fine, provided witness evidence is clear on this point. The size and resources of the employer will also be relevant here. For example, it's more likely that a tribunal will find it unreasonable for the same HR person to be involved at the investigation, the disciplinary and the appeal stages if they're in a larger organisation, particularly if the employee has complained about the level of their involvement in any case. The battleground for unfair dismissal cases is often the reasonableness of the investigation. The standard is what was reasonable in all the circumstances, and the range of reasonable responses test applies. The investigation must also be even-handed. It's not a criminal investigation, and so the employer doesn't have to prove beyond reasonable doubt that the employee did it. They just need to prove that the decision maker genuinely believes, on the balance of probabilities, that the employee is guilty, based on reasonable grounds and a reasonable investigation. In terms of bringing witnesses to disciplinary hearings, The ACAS code doesn't say that the employer must call its own witnesses or allow the employee to cross-examine witnesses during the disciplinary process. It doesn't even say that employees must be allowed to question their own witness, just that they should be allowed to call them if they wish. So, when considering requests for witnesses to be present during disciplinary hearings, you should think whether the witness is relevant and whether it's appropriate for them to attend, whilst bearing in mind that the internal disciplinary process is not meant to be a quasi-judicial proceeding. An interesting point arises in relation to anonymising witness statements collated as part of the investigation, and this is an issue I've dealt with recently. Now, according to case law, there's no universal requirement of natural justice or general principle of law that in all cases an employee must be shown copies of unanonymised statements. Rather, there's only a failure of natural justice if the essence of the case is not put to the employee. However, in general, we recommend that advice should be taken when considering the need to anonymise statements, and this should only be done when the safety of those involved is a real issue. In terms of deciding an appropriate outcome to the disciplinary hearing, there are two decisions to make: liability, then sanction. So firstly, did the employee do it? That is, based on the investigation, is the employee guilty? And secondly, if so, is there any need to impose a sanction? And if so, what is the appropriate sanction? In determining the appropriate sanction, an employer should consider mitigation, such as the employee's length of service, his record, his position, any special circumstances, for example ill health, whether this decision is consistent with other decisions within the business based on similar facts, and what the relevant policies say. Also, there's no harm in the key decision makers setting out in their outcome letters the fact that a lesser sanction was considered and why this may not have been appropriate in the circumstances. Now, another interesting point to consider is whether a disciplinary manager is entitled to make a decision in an employee's absence, and this is an issue we are often asked about in practice. This will depend on an employee's conduct. I've dealt with cases where the tribunal has found that it was reasonable for the decision to be taken without the employee present, given the employee's numerous delays and unreasonable conduct at meetings, which was designed to protract matters and avoid addressing the issues. Nevertheless, we do recommend that employees are given every opportunity to attend hearings and are offered alternatives, such as providing written representations or having meetings off-site. An employer should only make decisions in an employee's absence where it's absolutely necessary. In terms of warnings, when deciding the appropriate penalty, employers should take into account any live warnings, but can only take into account any expired warning and the underlying misconduct, where this isn't the principal reason for the dismissal. In other words, where the circumstances would have justified dismissal anyway. The ACAS code suggests that warnings should have a time limit of 12 months, that is 6 months for first written warnings and 12 months for final written warnings, but that doesn't always have to be the case. There's no reason why they can't be longer if the nature of the misconduct justifies it. A tribunal in an unfair dismissal case shouldn't generally look at whether the employee deserved the final written warning, which is taken into account in the subsequent decision to dismiss. However, where the warning was itself manifestly inappropriate or given for an oblique motive, the tribunal may take this into account in determining whether the subsequent dismissal was unfair. Also, it doesn't matter whether the employee appealed against the warning. This issue was considered in the Davies and Sandwell Metropolitan Borough Council case, which we covered in our news programme on the 10th of March 2011. Appeals are important, but it doesn't matter if they're a rehearing or review. A rehearing is where all of the evidence is reconsidered by the appeal manager. A review tends to be only where the employee's grounds of appeal are considered. As to which approach to take, it depends on the employee's specific grounds of appeal. But the key question is whether the process is fair overall. However, the appeal manager should be made aware that if they have a fundamental issue with the original outcome, they should still address that concern, even if they've only been asked to review the specific appeal points. In terms of the overlap between disciplinary and grievance decisions, the ACAS code provides that where an employee raises a grievance during a disciplinary process, the disciplinary process may be temporarily suspended in order to deal with the grievance. Where the grievance and disciplinary cases are related, it may, however, be appropriate to deal with both issues concurrently. And so if they're dealt with concurrently, we recommend that the outcome letter sets this out clearly and deals with the issues separately. Finally, where there are overlapping disciplinary and criminal proceedings, the ACAS code provides that if an employee is charged with or convicted of a criminal offence, this is not normally in itself reason for disciplinary action. Consideration needs to be given to what effect the charge or conviction has on the employee's suitability to do the job and their relationship with their employer, work colleagues and customers. There's no rule that says that an employer cannot dismiss when an employee doesn't comment on the internal disciplinary process because of the risk of self-incrimination, but it's worth bearing in mind that the employee may not want to comment during the internal process, not because of the risk of self-incrimination, but because to do so would give a heads up to the prosecution about their defence.
Thanks for that, Sally. So if you're in the process of or considering dismissing an employee for conduct reasons and have any concerns about how to carry out the process fairly, please do feel free to contact us, either through your usual AG contact or by clicking on the Contact Us box to the right of the screen, and we'll be more than happy to help. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.